Section 13. Definition of consent. The provision of the Contract Act relevant to a study of the effect of the mistake upon a contract that the party have purported to make may be not first. Full stop. Mistake may operate upon a contract in two ways. Mistake may operate upon a contract in a two-way. Full stop. It make firstly defeat the consent altogether that the party are supposed to have given. That is to say, the consent is unreal. Consent is unreal. Full stop. Secondly, the mistake may mislead the party as to the purpose which they contem- which they contem- contemplated हो गया contemplated the case in which the consent is defended consent is defeated or it retained under unreal for under section 13 full stop. This section define consent as follow: two or more persons are said to be consent when they are agree upon the same thing in the same sense. Same things in the same sense. Same things in the same sense. Definition of mistake. Definition of mistake: where the mistake does not defeat consent. Does not defeat consent but only mislead the party. Section 20 shall apply. Full stop. This section provide where both the party to in agreement or under a mistake has to a matter of fact. Matter of fact initially to the agreement. The agreement is void. The agreement is void. Explanation. In enormous opinion as to the value of the thing which form the subject matter of the agreement is not to be deemed a mistake has to a matter of fact. Mistake has to matter of fact हो गया. Section 20 will come into play. One where when both the party to in agreement are mistaken. Agreement are mistaken, though their mistake is as to a matter of fact. And 3. The fact about which they are mistake is initially to the agreement. Mistake is initially to the agreement. Section 21. Section 21. Mistake of effect of mistake has to law. Effect of mistake has to law. A contract is not voidable because it was caused by a mistake has to any law in force in India. In force in India, but a mistake has to a law not in force in India as the same effect has a mistake effect. Same effect has same is expect same effect same effect has mistake effect same effect of mistake of same effect has mistake effect. Section 21. Section 21. Effect of mistake has to law. Effect of mistake has to law. A contract is not voidable. A contract is not voidable because it was caused by a mistake has to any law in force in India. Law in force in India, but a mistake has to a law not in force in India has the same effect. Same effect has mistake effect. Same effect has mistake of effect. Mist of mistake of fact. Okay, mistake of fact. Section 22. Section 22. Contract caused by mistake of one party has to matter of fact. Matter of fact. A contract is not voidable merely because it was caused by one of the party to it and begin under a mistake has to a matter of fact. Mistake has to a matter of fact. Okay. Mistake has to a matter of fact. Okay. Where fact are initially. Section 22. Contract caused by mistake of one party has to matter of the effect. Matter of the effect. A contract is not voidable merely because it was caused by one of the party to it being under a mistake has to a matter of fact. Under a mistake of matter of fact. Mistake has to a identity. Mistake has to identity. Assumption of false identity. Assumption of false identity. Assumption of false identity. Mistake caused by take over of business. Take over to business. So get take over to business. Mistake of identity caused by fraud. Caused by fraud. Yeah, caused by fraud. Caused by fraud. Yeah, caused. Mistake has to subject matter. Mistake has to subject matter. Another fact initially to every agreement is the identity or quantity of the subject matter of the contract. Subject matter of the contract. Full stop. Mistake has to subject matter may take various form. Various from non-existent subject matter. Non-existent subject matter again. Non-existent subject matter. Mistake has to title or right. Title or right. Okay. Title or right. Title or right. Okay. Title. Limitation. Mistake operate to avoid in agreement subject to the following limitation. Mistake of both party under section 20 in agreement is void by reason of mistake when both party or mistake has to a matter of the fact initial to the agreement. Initial to the agreement full stop. This is further supplemented by the declaration in section 22 that a contract is not voidable merely because it was caused by one of the party to it being under a mistake has to matter of fact. Mistake has to matter of fact. Mistake has to matter of fact. Yeah. Mistake anonymous opinion about value of subject matter. About value of subject matter. Mistake of fact and not of law. Mistake should be of fact and not of law. For section 21, declare that a contract is not voidable because it is caused by mistake has to any law in force in India. Section carrying in illustration. Section legality of object. Legality of object. The fourth and the last requirement for the formation of a valid contract is that party must contract for a lawful object. Must contract for a lawful object. Full stop. In agreement the object of which is opposed to the law of the land may be neither unlawful or simply void. Simply void depending upon the provision of the law to which it is opposed. Unlawful agreement. Unlawful agreement section 23. Section 23 हो गया. Section 23 retender certain consideration and object has lawful. Object has lawful हो गया. Object has lawful. 23 what consideration and object are lawful and what not. What not हो गया. What not. What not. Section 23 what consideration and one consideration and object are lawful and what not. What not. Consideration or object of an agreement is lawful unless it is forbidden by law. It is forbidden by law. It is forbidden by law. Yeah. It is forbidden by the law. Yeah. It is forbidden by the law. It is forbidden by the law. Yeah. Object and consideration. Object and consideration. Object and consideration हो गया. Forbidden by law. Forbidden by law where the object of an agreement is forbidden by law. Where the object of an agreement is forbidden by law, the agreement is void. Where the object of an agreement is forbidden by law, the agreement is void. Law in this connection mean the law for the time being in force in India and therefore including Hindu and Mohammedan. Hindu and Mohammedan where the object of an agreement is forbidden by law, the agreement is void. Law in this connection mean the mean the law for the time being in force in India, and therefore including Hindu and Mohammedan law, also, and also principle of unwritten law, violation of licenses and permits, licenses and permit हो गया, licenses and permit, license and permit. Stay order, a stay order on construction which was obtained otherwise than under the allegation that the object of the contract was unlawful was held as not mounting to illegality of object, not mounting to illegality of object. Full stop. It may be that a construction under dispute circumstance dispute circumstance find may not find buyer, yet the contract cannot get ride under the doctrine of the illegality of the impossibility. Defeat any law. Defeat any law. Sometime the object of or the consideration for in agreement is such that thought not directly forbidden by law, it would be permitted defeat the provision of any law. Provision of any law. Yeah, provision of any law. Provision of any law. Yeah, provision of any law. Provision of any law. Law of friendly country. Law of the friendly country हो गया. Innocent violation. Innocent violation हो गया. Innocent violation. Void agreement. Giving the meaning of a void agreement, the act say in section 2 clause G. सेक्शन 2 क्लॉज जी क्या कहते हैं? इन एग्रीमेंट नॉट इन्फोर्सेबल बाय लॉ इज सेड टू बी वॉइड. इन एग्रीमेंट नॉट इन्फोर्सेबल बाय लॉ इज सेड टू बी वॉइड. In agreement not enforceable by law is said to be void. In agreement not enforceable by law is said to be void. Following type of agreement are declared to be void. 1. Agreement of which consideration and object are unlawful in a part section 24. Section 24. Agreement of which consideration and object are unlawful in part 24. Section 24. 2. Agreement without consideration. Section 25. Agreement without consideration. Section 25. Agreement in restraint of marriage. Section 26. Agreement in restraint 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 of marriage. Section 26. Agreement in restraint of trade. Section 26. 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 Agreement in restraint of the legal proceeding. Section 28. Section 28. Agreement in restraint of trade. Section 27. Agreement in restraint of trade. Section 27. Agreement in restraint of legal proceeding. Section 28. Unmeaning agreement. Section 29. और wagering agreement. Section 30. Wagering agreement. Section 30. Agreement to do impossible act. Section 56. Section 56 हो गया. ये मतलब क्या है? एक agreement of which consideration and object are unlawful in part of the section 24. Agreement without consideration. Section 25. Agreement in restraint of the marriage. 26. Agreement in restraint of trade. 27. Agreement in restraint of legal proceeding. Section 28. Unmeaning agreement. Section 29. Wagering agreement. Section 30. Wagering agreement. Section 30. Agreement to do impossible act हो गया 56. इन 56 हो गया 56. क्या हो गया 56? देखिए एग्रीमेंट इन विच ए पार्ट ऑफ द कंसिडरेशन ऑब्जेक्ट इज इन लॉफुल. ऑब्जेक्ट इन अनलॉफुल हो गया. ऑब्जेक्ट